For today's video, I'm going to be commenting on Chille's video about Egbert versus Boule. If you listen to any parts of this video, please make it the beginning and the very end. Fast forward if you have to, but most of my comments regarding the nature of this case will come towards the end of the video. In typical Chille fashion, he knows nothing about what he's talking about. Now, I'm not saying that a lay person can't read a case and understand what it says. And please don't think that I would insult the average everyday person like that. What I am saying is that I truly doubt that Chille fully read and understood this case. I always endeavor to be honest with you in my videos. I don't especially chop Chille's videos up to make him look stupid, not purposely. But if I do a video that makes him look a little silly, I let you know that you shouldn't take it very seriously and that it's a humorous video. In this case, I'm going to put a part of one of Chille's videos that he films later. I'm going to actually put it ahead of one that he filmed earlier. So I'm kind of putting them out of order. I'm putting the later video ahead of his earlier one. And I just want you to know that I have put two videos together. Chille is going to try to explain the case of Egbert versus Boule. And for my own, to make it easy on myself, from here on out, I'm just going to call it the Egbert opinion. Boule just sounds a little, I don't know. But from now on, I'm just referring to it as Egbert. The thing about Chille is that he always approaches case law with a bias in his mind. He has something he wants to prove, and he's going to use this case to try to prove it. And you should never approach reading an opinion like that. Also, please remember that when I'm analyzing this opinion, I'm not analyzing it as anything other than just another citizen. This is not a legal opinion, so there's no legal advice being given here. I'm giving this strictly as an educational video, just so you can understand what I believe the opinion says. And it's up to you to judge whether or not you think I'm right. Now, when I was teaching over at the college, I would teach my students, I would tell them, when you read an opinion of the court, just read it. Honestly, it's just that easy. Just read it. Now, I understand that there is a lot of technical language in the Egbert opinion. There's a lot of technical language in there. And it really is good it's very helpful. Let's say it's helpful if you have a core base of understanding of what some of these underlying legal concepts are, but you don't have to know those things because you can go look those up as well if you need to. So just read the opinion. It's not like they're trying to hide the ball on you here. Okay, so literally read. You're probably going to have to read it twice. I think I've read it now 4 or 5 times. Just read it one time through completely, and then go back and read it again, analyzing each part individually. Okay, that's how I would teach my students to start off with an opinion. So I went to law school about 30 years ago, and I never practiced in the area of civil law. My practice was almost exclusively as a criminal lawyer, where I served for about a little over a decade as a prosecutor, and then the balance of my career I was a defense lawyer. So when it comes to some of the civil things, I remember it from law school 30 years ago, but I sometimes have to go back and refresh myself on some of the civil procedure stuff because, those classes were a long time ago. So I do have to sometimes myself go back and look up those concepts. So don't be there, there's no shame in actually having to go look something up. I once had a physics professor tell me that you don't have to memorize all the equations as long as you know which book to go look at to look up the equation. So as long as you know how to look something else up, you can always understand an opinion. But that's getting complicated and complex, much more than I need to. Let's go ahead and start letting Chille try to explain his background in education to you.
I'm not a lawyer. I don't have a law degree. What I'm doing is I have just learned all that I possibly can, and now I just share with you guys what I know.
The blind leading the blind.
This would be the epitome of the blind leading the blind. Look, here's what I think is happening with Chille right now. Chille got really humiliated in court by Kate from Masshole Reports channel. And if you haven't seen that video, the frog has the complete audio of it. I believe Kate is going to put it out later if she hasn't done so already. But basically, in that court hearing, she schools him and the judge schools him. And he turns out looking like an ass, especially towards the end. You should watch it. Also, Josh from the Accountability for All channel, he's been talking really heavily about what a clown Chille was when he was in court, because Josh was there. So Chille is feeling a little paranoid right now that his followers are starting to see him as a legal fraud and that he's not as smart in the law as he claims to be. So he's trying to basically reinforce that he actually is a legal scholar by taking on reading this Supreme Court case that serendipitously has come out at around the same time. With Josh's videos, I know for a fact that Chille lost. He lost some followers from that. So to try to bolster himself back up with his followers, he is now trying to analyze a court case. And that's what he does in that later video I'm showing you. But then in the, that's what he does in the earlier video that I'm going to show you. But later on, he talks about his educational background and well, he goes on about other stuff. And he also tries to use, as you'll see in the later video, he tries to use this couple that's Harvard educated lawyers. And so that if you think that, well, Chille watches these people, so he's educating himself, then he must be educating himself on all things. Therefore, I should trust him. Because, obviously he's watching all these other videos that teaches him the law. So he doesn't have to get the traditional legal education because there's all these other lawyers out there telling him and teaching him. So, that could work. I'm not saying it won't, but what the ultimate idea for Chille here is that he wants to go back and look like he knows what he's talking about, that he is a legal scholar to his loyal subjects, basically. And to demonstrate that fact, he takes the entire video from this Harvard educated couple and he shows it to his followers. Notice that he never does that with any other subject. He never references, puts a link in the description, or talks about any other ways that he educates himself. He's only done it this one time. And so that's to prove to you that, well, I'm educating myself. But he never does it on any other subject. And it's because of this paranoia that he feels because he's lost followers.
When it comes to learning, you know, I absolutely love to learn from any person who can teach me something.
I included this little snippet of a clip just to show you that when Chille does something, like trying to tell his followers that, look, here I'm educating myself, look at me, I'm educating myself, and here's how. I'm willing to listen to anybody who will teach me. Well, we all know that he doesn't listen. But this is all done to demonstrate what I was telling you earlier. Since I hope that Chille actually watches this video, and that he really genuinely wants to learn and listen, and if he does, then I'm going to go ahead and try and teach a little bit of a law school lecture, and it will honestly be what I would consider first year level classes. So, you know, this is what you would get when you first enter law school, your first year. So Chille, if you're listening, get a pencil and get ready to take some notes.
And here are the transcripts right here when you take a look.
All right, now, no, what Chille has just showed you on the screen is actually the published opinion. He's so silly he doesn't know what he's talking about. The first 4 pages of the opinion is the syllabus. It's called the syllabus of the opinion. And I want you to think of the syllabus kind of like the cliff notes of a book. They're the summary of the opinion. You would never cite to language from the syllabus if you ever used this opinion to cite as something in a brief that you were writing. You can read the syllabus to get an idea of what the full text says, but you would never cite to that. All right, everybody understand that? Good. Real briefly, I'm going to digress since this is supposed to be a law school lecture. If you were a lawyer, let's say you're a lawyer, and you're writing a brief, and you've done your research, and you found 15 cases that discuss a particular issue that your brief is about. Now, you don't want to have to read 15 opinions that are each, anywhere between 40 and 50 pages long. This particular opinion, the Egbert opinion, is 48 pages. So you've got 15 briefs, or you got 15 opinions, and you've got to read them all for your brief. You don't want to read 15 times 40 to 50 pages. And you certainly don't want to have to print all that out because, that's a ream plus a paper. You're talking 750 or so pages. That's a book. So what you do is you read those first 2 or sometimes they go as many as 5 or 6. But, those first 2 pages, 3 pages of the syllabus to get the idea of what the opinion is about. You pick the one that sounds, the ones that you know, okay, these are the ones I want to read, or these are the ones I'm going to use. And those are the ones that you would print or read in their entirety. So that's the only reason I talk about, the importance of reading the syllabus.
At Egbert versus Boule. Egbert versus Boule, I think the name is. And so this is the oral breakdown. And what we're going to do is we're just going to cover the exact case law that was created by the Supreme Court and exactly what it means to you and me as far as when you cross over the border. You're going to have to deal with some things now because the Supreme Court has made it so that Border Patrol agents get absolute immunity.
See, this is how I know Chille didn't even read the opinion, because he's just completely wrong on this. He's conflating two very distinct concepts into one. So I actually know that he listened to the oral arguments, and he clearly didn't even understand what was being said during the oral arguments. What he is conflating is the different aspects. There's the criminal aspect, which is the unwarranted search and seizure under the Fourth Amendment, and the civil aspect of, is there a remedy for a violation of that? And that's really all that the court is dealing with, is there a civil remedy, which is, civil remedies are always money damages. And that's really all that the court is dealing with, is there a way for the defend or the plaintiff, the Boule, to seek a remedy for a violation of his Fourth Amendment rights civilly. It has nothing to do with immunity. Chille is just conflating the ideas. He doesn't understand the law, and that frustrates me.
Let's jump right into this case law so that you guys can see exactly what I'm looking at here. And this is really good stuff. This shows you that the government at the highest level, at the Supreme Court level, what they're going to do is they're going to create a system that completely and utterly blocks out any kind of accountability for the agents working within the government. And that's kind of what I talk about all the time, is the rule of law. You know, the first principle of the rule of law is that government and its agents are accountable to the rule of law.
Oh, Lord. This is already starting off badly. You can already see how Chille is trying to take this opinion, which has absolutely nothing to do with anything that he ever talks about, and try and twist it to make it fit his personal narrative. And it doesn't. It doesn't apply to things that Chille rants and raves about. This is so frustrating because he doesn't understand the law. He doesn't have any background in it. He's just wrong.
Video. Let's see exactly what the Supreme Court said in the oral arguments. If it gets too slow, I'll fast forward a little bit. But let's jump right into it because I do have a hard out at 1 o'clock. Let's jump right into this. Let's get into the Supreme Court hearing here.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, 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 for the court is now sitting. God save the United States and this honorable court.
All right, so at this point, Chille just plays the oral arguments for a while. And honestly, that can be kind of boring, even for me, and I'm a law nerd, so I'm going to cut most of what the oral arguments are out. If you want to listen to the oral arguments, there's a guy named Daniel Meeks. He has a channel, and I'll put a link in the description. He created a cartoon depicting what the oral arguments would have looked like, and he puts the soundtrack of the oral argument, within the cartoon. So it's the full, complete hearing. You'll hear all the oral arguments, but they don't allow cameras in the courtroom, so he created a cartoon to make it look like what you're seeing being said and by who. So it's a little easier to keep track of who the players are and who's talking. He did a really great job, so there will be a link in the description for that. But I'm just going to go ahead and explain a lot of stuff because at one point during the oral arguments, Chille pauses it and then he tries to invoke the Terry because he has to tie everything back to Terry. And Terry isn't even brought up in this opinion. Again, he's conflating the idea of criminal and civil. It has absolutely nothing to do with Terry, because Terry would be exclusively Fourth Amendment violations in the criminal realm, in the criminal aspect, whereas Egbert really deals with civil remedies available to a citizen who's had their Fourth Amendment rights violated. And from there, I'm going to start discussing that particular section of the opinion. If you get only one takeaway from this video, it should be that the Egbert case does not say that it is legal for a Border Patrol agent to enter your house without a warrant. It simply does not say that. At no point in the opinion, if Chille had read it, would it say anything in any shape or form close to that. Okay, so put that out of your head. All right, so you've put all of that out of your head. Now, let me give you a real quick thumbnail. That would be like, a really quick, short backstory on how this all starts. And it goes back about 50 years to a 1971 case called Bivens, B-I-V-E-N-S, Bivens v. 6 unknown federal narcotics agents. Bivens sued under the Fourth Amendment, under a violation of his Fourth Amendment rights, and the court in that case implied that there was a cause of action for a violation where there wasn't one statutorily. It implied one where it statutorily didn't exist. Now, in the 1970s, late 60s, early 70s, the court was, how would you say, in PC terms, progressive, liberal. There was more liberal justices, and it was more left-leaning. So it was more inclined to imply causes of actions in places where Congress had not expressly authorized one. Okay? All right, so in the years since that 1971 case, the court has started to lean more towards the conservative side. The late 60s, early 70s was a kind of a liberal time, and a lot of progressive ideas were coming out, and so the court tended to have more left-leaning judges on it. So starting in the 70s, 80s, 90s, we started to see the court kind of lean more towards the conservative side. Sure, there were some justices who came on that balanced the court back to the left, but it's a lot like a car. You got to keep trying to keep the wheel centered. Well, in this case, the court has been veering to the right pretty much ever since. And so how do I even put this? Okay, I've regathered my thoughts a little bit. So essentially, in the years since, the court has been leaning a little more conservative, and that fact is basically stated by Judge Thomas in the opinion when he says in the very beginning, probably second section 2, where he says, in fact, this court, we're long past the heady days in which this court assumed common law powers to create causes of action. What he is basically saying to you there, not basically saying to you there, it's essentially what he's saying to you there, is that they're slowly walking back the idea of judicial activism. Now, judicial activism is the idea that the judiciary protects or expands individual rights through its decisions that depart from established precedents or are independent of those precedents, sometimes even in opposition to those precedents, to support some supposed constitutional or legislative intent. Essentially, the court is backing away from the idea that it is going to legislate from the bench. In the old days of the 1970s, back when Bivens was created, the court would find these imaginative or creative ways to make up causes of action to satisfy their personal moral objectives or social justice objectives. And so they would just infer these rights out of this common law idea, whereas Justice Thomas and to a much greater degree Justice Scalia, those guys tend to be more strict constitutionalists, meaning if it doesn't say it in the law, it doesn't say it in the Constitution, and it's not expressly in some kind of a statute or code, if the legislature didn't write a law for it, then it's not happening. They're not going to infer something that isn't there. They're not going to read between the lines and create some cause of action. The court now, because it's conservative leaning, is saying they firmly believe that it's the legislative branch's job to write the law, and that the judicial branch's job is only to interpret the law that the legislature writes. So they're not going to imply things that aren't expressly there. And that is the big thing of this case. They're not going to see things that aren't there. Okay? So that's the biggest thing you should understand about this Egbert opinion. So it's going to seem like I'm rambling a little bit here, but I promise you that it does have some meaning about what I'm saying, and I think you'll probably hear it discussed in some of the TV news commentary people and other court watchers will bring this up. But all right, so let's get back to the story. Now, under this Bivens case, he was allowed to seek a remedy. He got monetary damages. So now Boule is saying, well, look, Bivens got it. I want this to happen. You got to use the same standards. Well, ever since Bivens, and we know it's conservative, they have been declining cases like that. Essentially, the court was saying, we did it that one time on Bivens' case, but that doesn't mean we're going to take every case like that. And basically, listen, bub, we're not going to take these cases. Congress, you're in a better position to create a law to do this, so we're not going to expand on this Bivens stuff anymore. We kind of did that back in the past. Bivens was kind of something we did that one time. We're not going to do it again. We don't feel like that's our job, and we're not going to do it. But they didn't completely rule it out either, because the court, the conservatives don't want to close that idea out altogether. They want to keep that available as an option, I assume, for something substantially more severe than what Boule experienced. But they didn't foreclose it all out. They didn't just shut Bivens down. They just said we're not going to do this all the time. Congress, make a law. So why didn't they shut Boule down and say, Boule, you can't use, well, they did shut Boule down and say, you can't use the Bivens test. But why didn't they just shut Bivens down completely and say, no more cases like this? Well, I don't know for sure, but I do have some personal feelings on it. And my personal opinion is that the conservatives want to keep this Bivens idea of, we'll see, it will imply certain things when we want to. They're going to keep that as an arrow kind of in their quiver, should they ever feel like they need to use it. But that they're not going to go ahead and just use that arrow right now. The term used to be blow your load, but then that took on a sexual connotation. Originally, it stood for when you had the flintlock style pistols, you would pack the pistol, or the flintlock style rifles, and you'd pack the rifle barrel and you'd pack the load into the barrel, and blowing your load would be wasting your shot. So they don't want to waste their shot on this particular case where they were really skeptical. If you read Justice Thomas' recitation of the facts of the case, you can see how absolutely skeptical he is of Boule's story. So they're not going to waste this time on this Boule guy by applying the Bivens test, because Bivens was so much more severe and Boule was not. Essentially, Boule, this Border Patrol agent, comes onto Boule's driveway, wants to investigate a passenger in his car who's arriving at his bed and breakfast to stay the night, who was suspected of being an illegal immigrant. And in the process, Boule got in the way, ordered the Border Patrol agent to leave. Then there's some controversy. No doubt that Boule was shoved. Boule claims he was knocked to the ground. You could tell Justice Thomas is skeptical of whether or not he was knocked to the ground. But either way, they basically said, you weren't even really harmed. But the Border Patrol agent did, in fact, come onto private property into the driveway. So it was a violation, but it didn't go into the house. So they're really saving that quiver, that arrow, that bullet, call it what you want, for when something is really severe. That's what I think. And what I really think, the thing that a lot of people on the internet are missing in this discussion of this case, is that this is the court really coming out with an opinion that says, hey, look, we've got the majority now. We have the conservative majority, and we're about to use it. And we're not going to imply rights where the legislature or the executive haven't figured out other remedies for these situations. The legislature is in a better place to solve these problems. Hey, executive branch, put something in your agency's rules that deal with this. Those are problems that are better solved in other places. And specifically in this case, they say this is better solved by Congress doing their job and creating a law. They're in a better place to fix a problem. The court sees the problem, but it says it's not our job to fix the problem. That's your job, okay? So I think too many people are just focusing on the wrong idea here. And I think what you'll also see when you read Justice Gorsuch, I can never pronounce his name, Gorsuch, he writes an opinion in agreement with the majority. He partially agrees and partially dissents. And on the very first page of his opinion, in the very first two paragraphs, he says that he feels that the court went too far from the idea of the separation of powers. That is that's the liberal approach, basically legislating from the bench. And now, and in his own words, he says, let me find it here. Uh, and now it is struggling to find its way back to the separation of powers, which is the conservative position. So they then fashioned this position in this opinion that basically forces the Congress to act, or in my guesstimation and what I suspect is knowing that Congress can't or won't act, and therefore when they fail to act, and all these people are all riled up with this idea that you can't hold agents accountable. There's all this talk on the internet is going to get people riled up, and if Congress doesn't act before the next midterm elections, that it's going to hurt their chances. And they get to do all of this all while they get to thumb their nose at Congress, which the court likes to do, and it's exerting its conservative dominance. It is basically saying we're the conservative majority, we're in charge now, and this is how it's going to go from now on. And you can kind of get that from Justice Sotomayor, I can never pronounce her name either, when she writes the dissent, because she does her best to scream and yell, individual rights, our future will be harmed, the sky is falling, the world is going to explode. She just creates this just horrible idea that the end is near if you let this happen. We have to infer sometimes, we have to imply, and the majority opinion says, yeah, we'll keep that option open, but we're not going to do it here. And Congress, get off your ass and do your job. So I think what they're doing is they're trying to make Congress look bad to hurt their chances in the midterms, and all while they get to say to the liberal minority, you don't get to call it anymore. We're in charge now. And while I'm not telling you I agree either way, neither liberal or conservative, which way they should go, I'm just telling you what I see them saying. So I actually think that this is so much bigger than anyone really understands, that the court is now saying, look, we're going to be very conservative from here on. And believe me, with the ages of these new justices that President Trump got put on, they're all in their 40s and 50s. They're going to be there for a long time. And that they're basically saying, we're the charge now. We're going to be here. This is the way it's going to be from here on out. Get used to it. Congress, you need to figure out how you're going to do this, because we're not going to do your job for you. We're not going to protect these people the way that we have in the past. We're going to be strict constitutionalists, strict interpretationalists, and that's just it from here on out. That's the way it's going to be. And that's probably how it really will be for about the next 30 years, while all of these people age to the point where they either die or decide to retire on their own. But, that's what I view as so much bigger than anything anybody realizes. And if you take away nothing, please know that Chille is completely wrong. He doesn't know anything he's talking about. Border Patrol agents, if you live within 100 miles of the border, are not going to be able to come and do a warrantless search of your house. That's not what it says. It says if that happens, okay, it's happened, and this person wants to bring a suit. We as the court don't see where they can do that, and we're not going to infer that there is a place that they can do that. If that's something that Congress thinks that should happen, that there should be some way for you to say, hey, these guys did this and they shouldn't have. Now I want a monetary remedy, then the court's not going to imply that there's one there. Congress should have to do that. And it's really very clear, it must say it 10 times in the opinion, that Congress is in a better place to determine when there should be a remedy for a violation like this particular violation of the Fourth Amendment. So that's the end of the video. I hope that my voice wasn't too slow. I'm still recovering, but I hope you enjoyed the video, and I hope that you leave a like, and subscribe to the channel if you're not already subscribed, and I hope you learned something. Thanks for watching.